All right, good afternoon, everyone. I'd like to welcome you to our Tuesday webinar. My name is Kathy Purdy. I'm the marketing manager here at Schoeneck King. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows throughout today's presentation. Once the webinar has ended, if you would take a moment to complete the brief survey, we would appreciate it as we share your suggestions and comments for future topics with our presenters. So to start us off today, I'm going to hand it over to Adam Mastrolio.
Kathy, thanks so much and welcome to everybody. Thank you for attending this week's installment of our weekly webinar. I want to make a note here at the beginning that you may have noticed today's reminder email had a new name for our weekly series, Business in 2021. As we come out of the pandemic and move forward, we will be covering topics that go beyond coronavirus. So we are reflecting that in the name of our weekly series. We're going to continue to discuss COVID-related updates and expand our topics to all relevant areas that are important to business today. So I wanted to make a note of that at the beginning in case some of you were wondering why the email looked a little different this week. Well, this week we have another great program, another packed program for you. We're going to be covering some additional FAQs related to that mask guidance that we got last week. And we're going to walk through the most recent IRS guidance on the COBRA subsidy from the American Rescue Plan Act, excuse me. We're going to provide a litigation update and also discuss some issues that you might want to consider in reevaluating your workplace safety plans. So first today is going to be Katie Anderson. She's going to provide our update from Albany.
All right. Yes, here we go. It's our weekly update from Albany, and you all know what that means. It is, where are we right now in New York State? Looking at the number of cases in New York, the great news is we continue to see that drop off happening. We're really getting very close to where we were last summer, which is excellent news. Also excellent news, as of today, the United States will have 50% of the adult population be vaccinated. Excellent news, means that we are just getting further and further away from the worst of it, hopefully. Looking at New York specifically, 45% of the entire population, so that includes children, are fully vaccinated. Over 50% of New Yorkers who are over 18 are fully vaccinated, and 54% have one dose. We've seen in the past couple of weeks, there's been new programs occurring about how we're going to be encouraging vaccinations. One of them is this pilot program that New York is doing over this week. It's called the Vax and Scratch program, where if you go to one of these, there's 10 state-run vaccination sites where if you go to it, you will receive a lottery ticket, scratch-off lottery ticket, where you could potentially win $5 million with that scratch-off ticket. This is a pilot program for this week. It's only at 10 vaccine sites, but when you look at what Ohio did, and they announced this program before New York, so in the beginning of May, they said, anybody who goes and gets a vaccine will be entered to win $5 million lottery. Ohio saw a 53% increase in vaccines. So that's great news. I think we're going to continue to see programs like this that are out there and existing. One other update with the vaccine, these reports came out after I finished the slides, but Moderna's vaccine, they are now seeking FDA emergency authorization for use with 12-year-olds and up. Their studies have shown that the vaccine has been safe for children 12 and up. So if that is approved, which potentially will be approved by the end of this week or next week, that means there will be 2 vaccines available for children 12 and up, or for everybody 12 and up at that point. So when I'm thinking about this New York guidance that they came out with last week, this is the song that keeps popping up in my head. Let's give them something to talk about. because man, somebody in the state government must watch these webinars and say, you know what, we needed to give them some more topics. So let's give them something to talk about. This CDC guidance is, you know, how New York is interpreting it is different from how the CDC has interpreted it. There are a lot of nuances. Teresa Rusnick, who's going to go after me, is going to go over a lot of the frequently asked questions about this guidance. But let me just give you some of the baseline rules to start with. Baseline rule here is businesses may continue to require masks for all individuals. That's just the full stop. That's the rule, that you can continue to do it. But if you were a business that can adopt the CDC rules, so you're not a healthcare provider or one of the other listed entities, and your business is not a place of congregation, as in it's not a place where you're hosting events, and you have fewer than 250 people indoors or 500 people outdoors, then you can adopt this rule that says that fully vaccinated individuals do not need to wear a mask. If you are doing that, you have a few choices as to how you're going to be doing it. One, you can either check for proof of vaccination. And so acceptable proof of vaccination are the CDC cards, the Excelsior Pass, or another digital application. Or you can use the honor system, which is, you know, you just say to people, if you're vaccinated, you don't have to wear your mask. And we hope that you aren't lying about this. For both of those, I strongly suggest that you are clearly communicating this policy with people. If you're a place with visitors, really clearly communicate that with signage that says what your policy is regarding masks, because every place is different. It's very confusing for people when they're walking in. They don't know what to do. So just clearly communicate what the policy is. Are you using the honor system? Just say, we're using the honor system for vaccines or for masks. Events. You know, events, it's a very different topic. If you are having an event with people that are going to be vaccinated or unvaccinated, I strongly suggest that you get in touch with an attorney to discuss the event guidance. The event guidance clearly favors hosting events for fully vaccinated individuals versus, you know, allowing unvaccinated people at the event. So if you have an event, get in touch with an attorney about it, because the guidance is confusing on it, and it would be, I could spend a whole webinar just talking about the event guidance itself. Looking at, you know, other masking concerns. We've got a question frequently, what about people who previously had COVID-19, you know, within the past 90 days, they had the antibody treatment. What do we do about them? If they're not vaccinated, they still need to wear a mask. That's the rule. There's no exception for them. There's no carve out. There is going to be a carve out on the next slide about a totally different topic for them, but not in this regard. And one other thing to note too, there's been some reports coming in about the efficacy of the vaccine for immunocompromised individuals, specifically looking at individuals who have received organ transplants or of any kind. The vaccine just doesn't really work as well, or if at all, for people who are who have received a transplant, because you're taking medication that really suppresses your immune system to the point where you're not attacking the organ in your body. So if you have, you know, if this is a situation you're going to be dealing with at your workplace, I strongly encourage you to get in touch with an attorney about this, because there are lots of things that mesh here, intersect. You have the ADA, you've got OSHA, you've got all types of things coming to a head here. So if that is the case, I strongly urge you to get in touch with an attorney about it. One other thing, and I wanted to just briefly go over this because I've been getting a lot of questions about it this past week, quarantine guidance for people when after an exposure. So just this is a reminder for people. If you're fully vaccinated and you are exposed to COVID and you have no symptoms, there's no quarantine. If you've recently recovered, as in you had COVID within the past 3 months, and you have no symptoms after an exposure, you still don't have to quarantine. Every other person, a quarantine is required. There's a certain essential worker exception there. So get in touch with one of us if you want to go over that again. But we're almost coming up on a year of that. That guidance's anniversary is coming right up. So very exciting for us. One final thing, travel. There are no quarantine requirements for asymptomatic travelers. That includes asymptomatic unvaccinated travelers who traveled abroad. Been getting a lot of questions about that in the last week. So I guess more and more people are going abroad, but as long as the person remains asymptomatic, there is no quarantine. With that, Adam, I'm going to kick it back to you. Oh, I have a final note. Oh, God. One last thing. This has been a big news story over the past week about child care camps, day camps, and overnight camps. Face coverings before yesterday were required for children 2 and up. Now, as of today, or as of yesterday, actually, face coverings are now recommended, not required for children at childcare, day camps, or overnight camps. There are certain exceptions, but, you know, again, get in touch with one of us. We'll be happy to walk you through it. Back to you, Adam.
Katie, before we move on, is that new day camp guidance located in the state guidance that's on the New York Forward website?
That's correct.
Great. Thank you very much, Katie. All right, now we're going to turn to Teresa Rusnek. You know, we monitor your questions that you provide to us during these webinars, and we answer as many as we can. But sometimes a topic is so, it's very clear we need to cover it in a little more depth. Last week, we had 180 questions that came up in this 45-minute session, most of which dealt with the new mask requirements. So we thought we would compile some of the greatest hits and have Teresa Rusnek give us a summary of the answers to those questions. So Teresa, take it away.
All right, thanks, Adam, and good afternoon, everyone. So like Adam said, I'm going to run through some of the questions that we got last week following the webinar, specifically related to masks and face coverings. And so these are quite a few of them, but I tried to pick out the ones I saw more than once. So the first one, basic question, how do we determine if an employee or visiting client, customer, consumer has been vaccinated? What are we allowed to require? As Katie said, you're allowed to require physical documentation of the vaccination via the vaccination card. You can also do an electronic record via the Excelsior Pass that New York has made available for people. That information is found in the reopening guidance that Katie mentioned, so you are allowed to require those things. I also think if you had an employee and they were able to give you a doctor's note certifying that they had been vaccinated, that would also be good enough for proof of vaccination. Of course, as Katie mentioned, you can also go on the honor system. You don't have to formally require anything. You can just trust people to tell you that they have been vaccinated or not. I liked her suggestion about whatever your policy is going to be, especially regarding your visitors. Please make sure you communicate that to them clearly, either before they arrive or as soon as they arrive. Second question, are employers still required to follow the guidelines listed in last year's New York Forward plans? For example, daily health screenings for employees and maintaining visitor logs. Yes, and yes, we still have to do daily health screenings. The New York Forward plan guidance is probably going to be updated, but right now the state's lagging behind a little bit on that. So for now, please continue to follow that guidance to the best of your abilities. What happens if an employee notifies us that they know an employee is not vaccinated and isn't wearing a mask? How can we address? As we know, if you're not vaccinated, you still have to wear a mask in the workplace and you still have to socially distance. If you've allowed your employees who are vaccinated not to wear masks and you run into this situation, I think the first thing you do is you ask the employee, right? I mean, hopefully by then you've required some kind of proof of vaccination from all of your employees. So you'll know if this person is vaccinated or not. But if for some reason you haven't, you're doing the honor system, it's fine to ask that person to show you proof of vaccination. And of course, if it turns out that they've lied to you and you can prove that, you're free to take other disciplinary measures in accordance with your usual policies. Next slide, please. Okay, so this question came up a bunch of times last week, so I wanted to make sure to address it today. If the accommodation is that the employee will wear a mask while indoors at work, Won't that telegraph that they hadn't gotten their vaccination? Maybe. But again, this is what New York is allowing us to do. If you aren't vaccinated, you have to wear a mask at work, and you have to socially distance. And if you are vaccinated, you can adopt the CDC guidelines and not require the mask and social distancing. Will this telegraph that someone hasn't gotten their vaccination? Maybe, maybe not. I personally know a number of people who are fully vaccinated who are still choosing to wear masks for their own personal reasons, and there's nothing wrong with that. So what, whether it will telegraph it or not, I don't think is necessarily an issue that an employer needs to be too concerned about in terms of that creating a viable disability or some other type of accommodation claim. I just don't think it's there based on the guidance that New York has allowed us to follow. With the mask mandate being lifted, can we require that all employees return to the office for work? Sure. If they're vaccinated and they don't have to socially distance, and let's say your workplace is small, then yeah, they can all come back to work if they're vaccinated and they don't have to socially distance. If you have some that aren't vaccinated and want to come back to work, or you're going to require them to come back to work, you need to make sure that your office is set up in a way that they can still socially distance and wear masks. But short of that, yes, everybody can come back to work as long as you can follow the guidance about that. Next question, we have we have branches in which we do not know the vaccination status of our members. Do our staff still have to wear masks and still socially distance? I'd recommend that. Again, as Katie said, you could do it on the honor system. I don't know as employers if that's necessarily something you want to do. I'd recommend asking for some type of proof of vaccination to avoid claims that you're, deliberately putting people at risk, or, whatever an employee may claim that you're doing or not doing. So I would recommend proof of vaccination if you are going to let people go maskless or not wear face coverings. And if you're not going to do that, I do recommend that they continue to wear the masks and that they still socially distance. Just make it easy on yourselves that way. Next slide, please. Can companies keep the mask requirement depending on the job? For example, customer facing versus in an office? Yes, I don't see anything to prohibit that. As long as you're doing it on a non-discriminatory basis, for example, not making all the women wear masks and the men can go maskless. As long as you're differentiating it based on a non-discriminatory basis, like customer facing versus in the office, I think that is fine if that's something that you want to do. What if the person has had COVID but no vaccination, mask or no mask? Yes, mask. Unfortunately, and I know the science may or may not support this, but people who have had COVID still need to wear a mask unless they've had COVID and been vaccinated. It's not whether or not they've had COVID, it's whether or not they've had the vaccine. And then finally, can we ask employees to place a sticker on their badge or wear a bracelet so that we don't have to keep asking if they are vaccinated? I think you probably can. I know in the healthcare setting, they've been doing that for some time. I might recommend putting it on the back of their badge or on the back of their name card so that, you're not necessarily advertising it to everyone, but I don't see, especially if the employees agree to it, a problem with doing that necessarily. I mean, after all, you're allowed to ask who's vaccinated and who's not, and those people are allowed at their option not to wear masks. So if you got their permission to put the sticker on their badge, I don't see how that would create too many problems in the workplace. And I think that's it. So those were some of our highlights from last week on the mask guidance. As always, if you have any questions, feel free to reach out to me or to any of the bond attorneys. And with that, I'll turn it back to Adam.
Teresa, thanks so much. This is obviously an evolving area. The governor put out his press release a couple of days, I think it was last Monday, which preceded the formal guidance document, which came out on the 19th. And there were significant differences in the governor's press release and the guidance document that was issued 2 days later. So we are going to make sure to keep our eye on any new developments. And for those of you attending these webinars, and if you've been attending, you know that we will alert you as soon as there is a change and as soon as we know anything. So thank you for staying with us as we continue to update these guidance documents. Okay, so next, one of the things we've done over the past year is try to stay up on litigation issues relating to COVID, whether it's suits being brought against employers or suits being brought against companies, any litigation that's been related to the COVID pandemic. We've tried to provide you with an update about that. So here to discuss the most recent COVID litigation update is Dan Pouts. Dan's a member in our Syracuse office, and he's been on here a number of times before.
Thank you so much, Adam. I appreciate the invite back. It's been a while now, but as Adam mentioned, there's a tremendous amount going on. It's not quite as sort of day-to-day as the guidance coming from state and local authorities, because litigation just by nature tends to move more slowly, particularly because right now courts are finally back to, we're conducting jury trials, we're doing depositions in person, and it's starting to feel somewhat normal again, which is a very welcome sight to many of us in the litigation world. But as Adam mentioned, I was back. I haven't been on this webinar in a couple of months, but there have been significant amounts of cases working their way through the system, both at the state and the federal level. And what I want to do today is, I know many of the questions that you folks have are probably the questions that I'm fielding on a daily basis multiple times. And what I found lately is that starting about 2 or 3 months ago, I think a lot of businesses were kind of kicking the can down the road in terms of commercial disputes to figure out whether or not there was going to be some relief offered from the state or federal government. And also, whether there were disputes, contractual disputes primarily, that could be resolved without having to turn to litigation. But where we are now is many of these cases have since been sued, and I've been being retained and contacted by clients involving primarily breach of contract actions. And when we're talking about breach of contract actions in the, COVID era, there's really 3 defenses that come up time and time and time again that are being litigated, and it's unclear still how courts are going to respond to those. And these 3 defenses, I'm sure many of you have heard of them. It's force majeure, which is essentially an unforeseen act of God that prevents a party from performing their contractual obligations. We also have impossibility of performance. Basically, it's impossible to perform your contractual obligations. And then frustration of purpose, which means the entire basis of the contract, because of COVID-19 related issues, it's no longer makes sense to have this contract in place. So those are the 3 defenses that have been the subject of much litigation as of late. Unfortunately, we haven't seen any court or any judge do a real deep dive into any of these 3, but we have seen some breadcrumbs as to where these things are going, and we can anticipate how, once there are substantive decisions, these issues are going to be decided. As a preliminary matter, some of us, kind of joke about how some people have taken advantage of the last 9 months or 10 months by saying, "No, it's COVID, it's related to COVID," when in fact it's not. And so recently we've had a decision out of county, it was a Supreme Court down in one of the 5 boroughs, where the judge basically said, enough is enough. COVID-19 is not a catch-all defense, regardless of what else may be going on. And in that case, it was a breach of contract case, and the defendant argued impossibility of performance, frustration of purpose, those types of defenses that we just talked about. And the judge basically said, look, you failed to abide by your contractual obligations well before March of 2020. So you can't show up now and say, well, it's due to COVID. And he sort of drew a line in the sand that said, if you're going to assert one of these defenses and try to prove them, you actually better have some proof other than to say it's related to COVID-19. So I think that was a welcome decision by many of us, particularly in the defense bar, because of the issues that we've been dealing with. Next, in terms of the force majeure clause, those are clauses that are typically contained in a contract. And what it says, as I mentioned before, was if there's an act of God that prevents one of the parties from performing, they're excused from that performance. What we've seen in the litigation lately involving force majeure is that unless the clause in the contract specifically refers to a pandemic or a national emergency, it's probably not enough to rely on what's gone on, even with the state and local related shutdowns. And what we found, particularly dealing with our clients, is that up until March of 2020, it was very, very, very unlikely that a force majeure clause was going to include specific language relating to a pandemic. I suspect that will change now, but as it stands, a lot of these contracts that the courts are interpreting don't have specific language related to a pandemic or a national emergency like this. Next, one thing to keep in mind with the impossibility of performance, I'm dealing with this now with a number of clients in terms of events that were scheduled far out in advance, and now they're trying to, one side or the other is trying to get out of those obligations. Courts now over the last 3 months have routinely held that financial hardship is not impossibility of performance or frustration of purpose. So in other words, this could create, this contractual obligation could create significant economic burden on you, but it doesn't mean it's impossible, and it doesn't mean that it frustrates the purpose of the contract. And we've seen that come up in a number of cases. One recent case was it was a class action case, a wage and hour case with the owner of a bunch of different fitness centers. And they had settled the case, and the owner of the fitness centers was obligated to make payments over the course of several months. And he stopped making those payments, claiming that because of Governor Cuomo's executive order that shut down and prohibited his ability to run a fitness center, that it was impossible for him to make these contractual payments. Well, of course, the judge said, look, it may be difficult for you to generate that type of revenue to make that settlement payment, but it's not objectively impossible. So if we're evaluating our contractual obligations, just know that if we're thinking of asserting impossibility of performance, that actually means impossibility of performance objectively. We also see this come up in residential and commercial real estate sales, where the closing date has been postponed and postponed and postponed. In one recent case, a business was going to acquire a hotel in Puerto Rico, and they said, geez, it doesn't make a lot of sense to buy a hotel at this point in time, and tried to get out of the contract. But the judge again said, just because it's unprofitable doesn't mean it's impossible. So keep that in mind. In terms of frustration of purpose, that's come up a lot in the commercial leasing context. It's also come up a lot in the wedding context, believe it or not. We've been contacted by a number of wedding venues and a number of brides and grooms who have said, because of the capacity restrictions and having to dance in a 6-foot square and things like that, it defeated the entire purpose of entering a wedding venue contract. Those cases, most of them have been resolved amicably by way of settlement. There are still a couple of wedding cases that are working their way through the system, and we're following those closely. Thankfully, a lot of those restrictions seem to have been lifted as of late. So by the summer of 2021, we think that weddings might look somewhat like they used to. But in a recent case down in New York City, there was a commercial lease that provided that this lease space could only be used for one specific purpose, which was a nightclub. And of course, due to the restrictions, you can't operate, or at least at that time, could not operate a nightclub. And the court said, yeah, no, that was clearly a frustration of purpose because the lease was so specific with respect to how the property could be used. So again, if you're evaluating whether or not you have a frustration of purpose defense or someone on the other side could, you have to look at the specific language in the lease or in the contract to determine how viable that defense would be, because that's immediately what courts are looking to. The last thing I want to touch on is, and it hasn't been something that's hit in New York State yet, although we fully anticipate it will be. I just looked at a recent filing out of New Mexico where a corrections officer was suing his employer, the county, over a requirement that first responders and other employees, including correction officers, were mandated to get a vaccine. And that case hasn't gotten too far off the ground in terms of discoveries. There hasn't been any substantive court findings yet, but New Mexico is not going to be alone in that regard. When we talk about vaccines, of course, we're going to talk about whether or not it's mandatory and how much employers can force the hands of employees with respect to vaccinations. So we'll continue to monitor that. And I suspect that in the not too distant future, I'll be back to give another update in that regard. So thank you again, Adam, for having me. I appreciate the opportunity.
Thanks, Dan. Always interesting to hear what's going on in the courts as it relates to COVID. Next, we're going to turn to the ARPA's COBRA subsidy requirement, which John Godso, who's joining us now, has spoken on before on this webinar, but we just got some recent information from the IRS, and we wanted to provide everyone with an update. So John, please take it away.
Okay, thanks, Adam. Good afternoon, everyone. So today we're going to talk about recently issued IRS frequently asked questions. There was just issued, I think, Wednesday of last week. It's guidance that we've been waiting for to provide a little bit more information and background regarding the statute that was initially enacted back in the beginning of March. As background, if folks remember, following the enactment of the statute, we had some guidance from the DOL in the beginning of April regarding the notices that need to be sent out for ARPA, and you can find those on the DOL's website. Included with those notices was also some information from the DOL side interpreting ARPA, but the guidance that we received just last week from the IRS is much more comprehensive, much more helpful for employers and plan sponsors to understand their COBRA obligations with respect to subsidy. And just to go back, rewind the clock here for a minute, just as an overview of the subsidy, it basically applies with respect to COBRA qualifying events that were either a reduction in hours or an involuntary termination of employment. The subsidy period extends from April 1 to September 30. So anyone who has a COBRA period during that time is potentially eligible for the subsidy if they had an eligible qualifying event, again, the reduction in hours or involuntary termination of employment, and aren't eligible for other group health plan coverage. So the new notice is IRS Notice 2021-31. It has 86 question and answers, so it's pretty comprehensive. It's over 40 pages. Listed here are the various areas that the IRS touched on. And I think some of these are helpful. I'm going to touch on some of these just as reminders regarding some of the frequently asked questions that we get here at Bond regarding the subsidy. And, you know, if you want to get into it more comprehensive, you can look at the guidance. Obviously, you can give us a call too for more information. But some of the things that we've seen a number of questions on are, many people understand the subsidy relates to an involuntary termination of employment, for example. But recall, there are two triggering events for the subsidy to potentially apply. The other is a reduction in hours. And that does not need to be an involuntary reduction in hours. So this could be a circumstance where someone requests a leave of absence, for example, and thereby reduces their number of hours to be eligible for the group health plan, and therefore is provided with a COBRA notice as a result of that. That event is also a qualifying event that may qualify someone for the COBRA subsidy under the guidance. So I think a lot of people are thinking of this as just involuntary actions. On the reduction in hours side, it can be voluntary or involuntary. So that is one issue that we've seen questions from clients on. Another question we've seen is, well, what's eligible for the subsidy? Is it just our group health plan? Is it other plans that we maintain? And it's really any group health plan that's subject to COBRA. So this would be extended to your vision plan, your dental plan, for example. Health reimbursement arrangements are also subject to this rule. The only exception is a health flexible spending account. That's the one carve out from the ARPA subsidy. But you need to recall that this doesn't just apply to your major group health plan. It applies to other group health plans that are subject to COBRA as well. The other general category that I'll touch on here, just because there's a deadline coming up, is this extended election period. And if folks remember, again, this subsidy goes from April 1 to September 30, but there's also a look back element to this requirement. And basically, you have this extended election period. If folks' COBRA period would extend into the April 1 to September 30 based on a qualifying event that occurred in the past. So for those folks, we need to send out an extended election period notice to those individuals by May 31st. Again, those notices can be found, or at least the model notices can be found on the DOL website. But that is one deadline that's upcoming here that folks should be aware of with regard to implementing the COBRA subsidy. If we can go to the next slide, please. So here are 5 takeaways regarding the new guidance. Some of this, we had some information, I think, based on the prior DOL guidance, but these are questions that we've often seen from employers regarding implementing the subsidy and how it should be administered. If you're familiar with the documentation that the DOL has provided so far regarding the subsidy, in addition to either a general notice that can be provided for those folks who go out due to a COBRA event from now until September 30, there's also the extended election notice, and that's for your folks who had a prior qualifying event that occurred before April 1, but whose COBRA period extends beyond April 1 into the April 1, September 30 period. The third document that's provided on the DOL's website is basically a summary document that includes a attestation provision or section where the qualified beneficiary can indicate whether he or she is eligible for the subsidy due to an involuntary termination or reduction in hours, and whether he or she has other disqualifying coverage. So for example, if they're eligible for or enrolled in another group health plan, they are not eligible for the subsidy. Same thing if they are enrolled in Medicare or eligible for Medicare. So not everyone is eligible for the subsidy just because they may have had an involuntary termination or reduction of hour qualifying events within the qualifying period. However, you can require, and we've been advising employers to do this, to include that summary with the packets that they provide to their qualified beneficiaries. And the updated IRS guidance indicates that you can use that self-certification made by the qualified beneficiary to assist you in your determination of either subsidy eligibility as a result of involuntary termination or reduction in hours, or the fact that that individual is not eligible for other coverage. So this really goes to the substantiation and documentation that you want to keep regarding these subsidy determinations, because at the end of the day, you're going to be making a request or an application for credit against your payroll tax to offset these subsidies that you're providing to eligible individuals. And the IRS is asking for you to keep this documentation in your file. So you don't have to require that self-certification, but it would be a helpful additional piece of information in your file regarding whether the person is eligible for the subsidy or not, and not eligible for other coverage, thereby disqualifying that individual. So think about the files that you're about to keep for individuals who may be potentially subsidy eligible, just in case there might be an IRS audit down the road in connection with any premium tax credits that you may request. Number 2, there's a lot of questions about, well, what is an involuntary termination? We didn't have any clear guidance until these Q&As. And one thing we get a lot of questions on, well, what about a situation where someone has voluntarily resigned, but it was really in connection with a situation where if they didn't resign, they basically were going to be terminated, and they were knowledgeable of that fact. We told them in advance, if you don't take this opportunity to resign your position, we are going to terminate you. What the guidance says, and this is consistent with guidance that was issued back in 2009 regarding a similar COBRA subsidy, is that that constitutes an involuntary termination. If that person had knowledge that if he or she did not voluntarily resign, the employer was going to terminate that individual. So it's based really on a facts and circumstances analysis. So what it's characterized in your records, perhaps, as a resignation, isn't necessarily determinative. So this is another reason to keep good documentation regarding anyone that you're providing the COBRA subsidy to. Third point that we hear a lot about is, well, what about if this is an involuntary termination for cause? In those situations, understandably, many employers may not want to reach back out to employees that were terminated previously to provide information regarding the subsidy. There is really no exception for providing the subsidy, unless on the front end, when you initially offered COBRA or the COBRA decision was being made, you denied COBRA due to what's under COBRA, it's called the gross misconduct exception. And so that's a very limited exception. In most cases, many situations won't fall under gross misconduct, but it's really that determination you made back when COBRA was initially, that COBRA determination was made, that is guiding. For example, if you previously offered that individual COBRA You can't now 6 months later, 3 months later and say, oh, well, that termination was due to gross misconduct, and therefore I'm not going to make this individual eligible for the COBRA subsidy. It's really tied to that initial decision. So if you've already offered the individual COBRA, even if you think it might rise to gross misconduct, if you didn't make that determination on the front end, you can't make that determination with respect to the subsidy. So something to keep in mind. Number 4, this relates to state law versus federal COBRA. Many states, such as New York, have a mini COBRA law. And there's also overlays with federal COBRA under ERISA and code provisions. And so this distinction relates to the more or less many small employers who may only be subject to New York mini COBRA, less than 20 employees. The extended election period that I just spoke about, where you have to reach back to employees who may have been terminated previously, but whose COBRA period would extend into April 1 to September 30 if they had elected, is not applicable with respect to state coverage. If you're only providing the subsidy, or you're only providing COBRA under state law, that extended election period is not a requirement under federal ARPA to give out those extended election period notices. So that is a distinction between some smaller employers and larger employers who are subject to the federal COBRA law. Number 5, the amount of the premium credit does not include any amount of subsidy the employer would have otherwise provided. So what does that mean? So think about a situation where you might have a severance plan that applies with respect to involuntary termination, and pursuant to that severance plan, you agreed to subsidize some portion or all of the COBRA premium that may be applicable for a set period of time, say 3 months, say 6 months. If that time period occurs during the COBRA subsidy period, April 1 to September 30, and you would be subsidizing as the employer that amount anyway, that portion of the COBRA premium is not eligible for the premium tax or the tax credit that you can apply for. So if you've already obligated yourself, or you have an obligation to pay for an individual's COBRA, you cannot receive a tax credit against that amount. So it's really only the kind of general COBRA situation where you haven't made that commitment to pay COBRA on behalf of the employee that you're eligible to apply for the subsidy. So those are some of the big picture takeaways from the guidance. Again, it's pretty comprehensive, 40 pages, 86 Q&As, covers a lot of ground. Certainly the one thing to keep in mind right now, I think the most immediate thing to keep in mind right now is the May 31 deadline for getting out your extended election period notices if you're subject to that requirement. And I know many people have been working on those and trying to get that information together, but that's the first deadline to think about. And then, throughout the April 1 to September 30 period, you should be continuing to be providing the model notice or some form of notice that provides information about the ARPA subsidy to those individuals who go out on COBRA during the subsidy period. With that, I'll kick it back to you, Adam.
John, thanks so much. There's a lot there, a lot of information, a lot of rules. So if anyone has specific questions, please reach out to John or anyone in our employee benefits group. All right, so the last thing I wanted to talk about quickly, and I've seen some questions in the chat about this, is COVID safety plans. Everybody put together your workplace safety plans in the last year, whether you were in the manufacturing industry or you were an office employer. You had to put together a workplace safety plan based upon the guidance that New York State put out last June and July. What I wanted to talk about is what changes should you be making to those plans now? What should you be looking at and potentially modifying based upon the flurry of guidance that we've been receiving in the past weeks? So first of all, if you recall, your workplace safety plans all have the same common elements. You're going to have social distancing rules, you're going to have PPE rules, hygiene and cleaning, communication, screening, and then response to infection, including when employees can return to work. So based on some of the recent guidance that we've gotten, you may want to change the language in those plans as it relates to some of those issues. So for example, with respect to masks and social distancing, if you are going to be adopting a plan that complies with the CDC guidance, as New York State told you you can, then you should take a look at your workplace safety plan to make sure that it is consistent with whatever policy that you've adopted. In addition, if you are going to adopt the state's guidance as it relates to vaccinated individuals and quarantine requirements, you want to update your workplace safety plan. So for example, if you have someone who is fully vaccinated, who has a close contact with a positive case, you might want to say they can continue to come to work, because under the CDC guidance and the state's guidance, individuals who are fully vaccinated do not have to quarantine following a close contact with a positive case. So if that's where you want to go with your employees, then that's something you should look at in your workplace safety plan. I've seen a number of questions in the chat today about whether or not you have to continue to screen your employees. And the answer is yes. For now, there has been no change in the screening requirement, whether or not your employees are vaccinated. So we anticipate that this will change at some point in the future, because the vaccination status changes your response to certain questions on that screening questionnaire. But for now, you have to continue asking all employees the screening questions. I saw a question about temperature checks as well. You can continue to utilize temperature checks at your workplace if you want to. There was never a requirement that you conduct temperature checks. So don't start now if you didn't before, but you can continue to do temperature checks if you want to. You may also want to look at your screening questionnaire and or your plan as it relates to travel. On April 10th, the state, as Katie mentioned earlier on in the presentation, on April 10th, the state put out new travel guidance, which does not require a quarantine or a work furlough following either domestic or international travel. So if you're still asking the question on your daily screening questionnaire about travel, you might want to look at that and remove it, because it is no longer relevant given the update in the guidance. One other thing that I wanted to mention briefly as it relates to your COVID safety plans is the elephant in the room, which is the HERO Act. As we've talked about on the last couple of webinars, the HERO Act was recently passed, and one of the elements of the HERO Act is that it requires employers to adopt more specific plans to prevent against the spread of airborne illnesses. We are still waiting for the technical changes to the statute that the governor's office promised. And then we're also anticipating the industry-specific template plans that the Department of Labor is supposed to be providing. So I would encourage you all to go through, look at your plans, try to figure out if any changes are needed based on the changes in guidance, some of which I've just talked about, and keep your eyes out for anything related to template plans and the HERO Act. So thank you again, everyone, for attending this week. We really appreciate your continued participation in these webinars. Our information is on the screen now for you. If you have any questions about anything we talked about, please feel free to reach out and we'd be happy to talk to you. So take care, have a great week, and we'll see you next week.